Hi everyone, I'm Taylor Hudak and I am outside Woolwich Crown Court. Today wraps up day 2 of Julian Assange's full extradition hearing. Joining me right now is my colleague and journalist Tareq Haddad. Tareq was able to be in the courtroom yesterday and today. Tareq, can you just briefly describe a general overview of what took place in court today?
So today was mostly the defense going through some of the allegations or the indictments that the prosecution had made. So one of the main kind of lines of discourse today was that Chelsea Manning, the way that she had provided the documents to WikiLeaks, it was inspired by kind of, as was mentioned in her court-martial, was that she was inspired because it was a public interest to get these documents out. It wasn't because WikiLeaks had solicited the information. We had a very long discussion about the WikiLeaks Most Wanted list, where the defense, Mark Summers QC, had gone through what was on the Most Wanted list and they compared it with what actually Chelsea Manning had provided to WikiLeaks, and there was discrepancies between what was actually on the Most Wanted list and what Chelsea Manning provided, and it showed that what Chelsea Manning provided to WikiLeaks was kind of based on her own volition of what she thought was important, and she actually provided documents that weren't asked for, and the documents that were asked for on the Most Wanted list were not delivered to WikiLeaks. And then we also discussed the password hash, which was central to one of the charges made. The US prosecution's version of events, I guess, is that Julian Assange helped Manning crack that password in order to steal more documents. What came out in court today and was already previously discussed in Chelsea Manning's court-martial is that she had access to all of the documents that she provided to WikiLeaks without any hacked password, and the password was actually used for not just Chelsea Manning but several other soldiers to play video games, download software, download movies onto their computers. So they're all obviously serving members of the military, and it was just a common practice among many members of service members to, just have access to certain music and entertainment on their laptops.
So is it fair to say that the prosecution perhaps maybe misconstrued this helping of getting into the computer?
Yes, and that's the kind of resting argument of the defense today, is that the prosecution has severely maligned the actions that took place, and they're using that as an argument to say that the judge shouldn't accept their version of offence, and they gave 2 examples in case law of how extradition wasn't granted because the prosecution had given a false account of the charges. So one of the examples that they gave was Castillo, from a case from Spain in the 1980s. The Spanish government had told the UK government that the wanted individual Castillo had placed a bomb under a car belonging to a policeman, and so he was wanted for murder and grievous bodily harm. And it kind of transpired in the proceedings that the bomb was placed actually 150 meters away from the police officer, and it was nowhere near anyone. So the extradition wasn't granted in that request because through the fact-finding mission it came out that because we now know that the bomb was 150 meters away, that would not constitute a crime in the United Kingdom because we have to demonstrate dual criminality. So they're arguing that the same thing should be done with Julian Assange, is that if we have a fact-finding mission to consider what the charges should really be, would they still be a crime in the UK? And the argument is that Julian Assange didn't put any lives at risk, and that was again something that was discussed in length today. We discussed how Julian Assange had taken, many steps and precautions to avoid harming informants of the US government, and how it was actually people involved with The Guardian that were involved in that. So they're arguing that there was no risk because of the release of the data, and so the charges that the US government are alleging should be changed, and then once those are considered under dual criminality, that would not constitute an offence under UK law.
Okay, and then lastly, I know there's been some misconceptions about what took place in court today. Many people believe that this new revelation about U.S. intelligence trying to put an end to this situation in the embassy was brought up today, but it was in fact brought up yesterday. Can you briefly describe what was said in court about that issue?
Sure. So the issue that we're talking about is that I believe, I'm not sure who the people involved were, but I believe it was people within UC Global and with the CIA were discussing the possibilities of either poisoning Julian Assange or kidnapping him out of the embassy. I believe some of that has been previously reported, but the reason they were bringing that case forward is some of the protections under the extradition treaty is that someone shouldn't be extradited to a country where their lives are going to be at risk or they're going to receive disproportionate sentencing. So part of that argument was in a wider context of he should not be extradited, because if the US government has already considered poisoning him and kidnapping him and doing these kind of things, he's not going to be safe in a US prison or on US soil, and he's not going to receive a fair trial because there's that assumption of guilt before.
What can we expect tomorrow?
Tomorrow, I think we're going to discuss the actual United States-UK treaty for extradition, and we're going to be talking very specifically about the legal points regarding is espionage a political crime, and that will be a big part of the case.
All right, Tareq Haddad, thank you.